So what is the problem with structuring that inquiry into actual evidence as a summary judgment motion, which is the structure of which is designed to ferret out whether there is an actual dispute of fact?
Right.
If the judge can consider the materials on a 12b1, and theoretically could even hold a trial to resolve disputed facts on subject matter jurisdiction before getting to the merits,
Right.
why can't the judge also structure that same inquiry into the same evidence as a summary judgment motion?
Well, it was, in order to be able to transfer it into a 12b1 into a motion for summary judgment, there has to be evidence submitted to support it. He didn't submit evidence in the motion to dismiss, and he didn't submit any evidence, which would have been the foreclosure deed, when he moved for a motion for summary judgment. So without any affidavits or anything of that sort to back up his motion for summary judgment, it should have been denied on that alone.
You're saying there was no evidence submitted in support of the motion for summary judgment?
Correct. So if he bought for the foreclosure and knowing that it's forged, then that's uttering a forged document, and I'm sure that they don't want to do that, which is exactly why I went with a tri-title, because that makes them prove their case first, and he'd have to bring in the forged deed, and he can't, because it's a forgery. So I specifically went with a tri-title, and then it was treated as a quiet title, saying that I have to prove my title first. Now, Abate, the reason why Abate had, I'm sorry, I'm just drawing a blank. The reason why Abate was able to, the difference, the distinguishment between Abate and my case is that was between a mortgagor and a mortgagee. There was no adversity between the claims because it's they both have a claim. He is not the mortgagee, so there is adversity here. So the land court took that ruling on Abate and applied it to me, but in my circumstance, it's not there. So my record title, all I have to show is that I had record title, and I did that. I showed him my deed and such. And also Abate, they could not prove, the judge found that no matter the arguments that he made to say the assignment was was void, was not provable. Now, I can prove, and I submitted an affidavit and an expert witness, plus the forgery is so obvious, it's obviously a forgery. I did show how it could be.
So I think what the way the judge resolved that argument is by saying that the summary process judgment is entitled to claim preclusive effect. And you, of course, have pointed to Chapter 239, Section 7. My question is, 239.7 says a summary process judgment, in essence, shall not have claim preclusive effect in a subsequent action to recover the land or tenements or damages for trespass. How is a tri-title action an action to recover land? In particular, where you, as the plaintiff in the tri-title action, need to allege that you're in possession of the land already in order to bring the case.
Right, so during the time, I established jurisdiction by having possession at the time, and then he had it evicted. So by the time that they brought that motion forward, I was not in possession anymore, and I was trying to recover land. So
Well, I didn't see a request for relief in your complaint or elsewhere that asked that you be restored to possession. And my question is, as a general matter, where a tri-title action requires the plaintiff to allege possession, how is a tri-title action the sort of action to recover land that is within the prohibition on claim preclusion effect in 239.7?
Well, at the time that I claimed it, I had a eviction notice executed, issued from the housing court. So it was inevitable that I was going to be dispossessed of the home.
Of course, you moved for the preliminary injunction to stop that. You ended up losing that motion.
Correct.
But as a general matter, a tri-title action where one has to allege possession in order to bring the case in the first place, how is that an action to recover land as that phrase is used in chapter 239, section 7?
Well, I would say it's because I already had an eviction notice, an eviction order to be evicted. So I was trying to, have it so that he would recognize that the housing court was void and that I would not be evicted from the order.
Is there anything, you've talked a good deal about the various options that are available for relief under the tri-title statute, and particularly if the plaintiff makes the step one showing, then the defendant can either default or appear and claim title and be required to bring an action. But where in that list of options in the tri-title statute is there an option for a judgment that would restore the plaintiff to possession?
But it wasn't about being restored to possession, it was about, I also asked for a declaratory judgment, saying that the title is still in my name, that the forgeries nullified the foreclosure itself. So if he did not claim title, then the motion for summary judgment should never have been heard in the first place, because he lost all rights adverse to me, plus the right to defend against it. So the motion for summary judgment is, I phrased it as the land court losing jurisdiction, and I don't know if that's the right verbiage, and I'm not an attorney, so I don't know the verbiage, but he didn't have any rights. And if he defaults, then he loses, as a matter of law, his right to have or defend any rights adverse to me. So he defaulted because he didn't claim title, and the stipulation of showing the court why he wouldn't have to bring a case against me is stipulated on him having claimed title. So the motion for summary judgment is void, or I don't know if that's the right.
He only has to claim title if you get to step 2 in the tri-title process, or the second action, so-called.
Well, you can't even argue it. It says if he claims title, then he can show the court why he need not bring an action. But he didn't claim title, so he had no right to even, at that point of not.
What he needs to do under the statute is show cause why he shouldn't be compelled to bring an action.
What's that?
What he needs to do at step 1, or has the option of doing, is show cause why he shouldn't be required to bring an action.
Right, he had to claim title first. If he didn't claim title, he didn't have the right to show cause at all.
And didn't the motion to dismiss claim title?
What's that?
Didn't the motion to dismiss and the motion for summary judgment argue that he had title? Not he, Reed.
No, and in his brief, that's why I asked it to go back to the land court. In his brief, he had admitted that he did not claim title. So if he didn't claim title, he had
at all, or just that he didn't, that Reed didn't need to include a counterclaim for title in its answer?
Well, you either have to include traditionally they allow that if he makes a counterclaim, then that's considered making a claim.
Right, but is that the only way?
Or he has to initiate a claim against me. And without that claim against my, bringing a claim against me, once I establish record title and possession, then it goes to step 2, and step 2 is where he has to bring an action against me. And he didn't make a claim. He didn't submit a claim, a counterclaim, or an action against me. And the stipulation of showing why you don't have to bring the claim is only if you make a claim of title. It says if he makes a claim of title. You can't just ignore those words. They're in there in the statute for a reason. And if he claimed title, he'd have to, at least in this motion for summary judgment, attach the forged deed. And that's uttering a forged document. He can't do that. So he can't claim title. Not in a motion, he can't attach it.
So your time is up. Let's see if there's any more questions.
Oh, I'm sorry about that.
No, okay, so, nice job. We'll hear from the appellee.
Good morning. May it please the court, David Summer for Ream Property. I think Justice Sachs hit it right on the head, which is that in this particular case, before Ream had an obligation to bring a suit with respect to title, Mr. Bigelow had to reach step 2 of the test. And in this particular case, he needs to prove record title and possession. And with respect to the forged deeds, and he makes a big deal about these, all these deeds are forged. What he's referring to, of course, is he's alleging the deeds from the bank to Ream are forged. The problem with that is that if we, and I'm not conceding that these deeds are forged, I just want to make that clear, but if the deeds were forged from the bank to Ream, the issue is that Mr. Bigelow does not then get reinvested with title. The title would go back to the bank. So when you have a foreclosure auction, of course, once the hammer comes down at the auction, Mr. Bigelow's title gets extinguished. And I think he's just ignoring that completely and saying that, well, we have these forged deeds, and the forged deed from the bank to Ream somehow reinvests him with title. The most that it would do is it would reinvest the bank with title. It wouldn't reinvest Mr. Bigelow. And we've had multiple.
When is the moment? I'm following your argument. When is the moment then that Mr. Bigelow, according to you, lost title?
Right at the foreclosure sale. If you look at the Outpost Cafe versus Fairhaven Bank case, 3 Mass Ave Court 1. The court says the equity of redemption is gone. It's barred as soon as the property is at auction and knocked down at the foreclosure sale. Right then and there, Mr. Bigelow's title gets extinguished. And we've had multiple cases here. We've had a foreclosure case, which Mr. Bigelow didn't seem to contest or appeal or anything. Then we have the housing court case, which he vigorously contested.
Just to clarify, there's not a foreclosure case. There was a foreclosure.
There was a foreclosure, right?
Okay.
Right. There was a foreclosure, which of course is a court action, right? He had to go to land court, or the bank had to go to land court. He had the housing court case, which he vigorously contested, including in this particular court. And the housing court, in their analysis, did say that Ream is the owner of the property. Now he brings up the fact that he wants this court now to invalidate the housing court case. Of course, now we're here on an appeal of the land court case. With respect to the housing court case, he did bring up these issues in the housing court. He filed a 60B motion. He could have very well have appealed that 60B motion.
Now, he says he didn't get notice of that decision on the 60B in time to appeal it. I gather your response would be, if he didn't get notice, then that's an issue of requesting leave to take a late appeal.
Right, he could have done that. Certainly he got notice before he filed the land court case, right? So at that particular point, he could have, which of course, I don't recall precisely.
When did he get notice of the housing court decision on the 60B?
What was that?
When did he get notice of the housing court decision on the 60B? He said, I think in the transcript of the summary judgment argument, that he was reviewing the housing court docket in preparation for an argument.
Right, I think the argument was in January, the year is escaping me, but he was preparing for the appeals court argument with respect to the housing court case, and he saw 60B had been denied. But then instead of taking a late appeal based on the fact that he never purportedly received notice. He then files the subsequent action in the land court to invalidate the housing court action.
Since since claim preclusion is obviously an issue here, I want to make sure you get a chance to address what does Chapter 239, Section 7 mean when it refers to an action to recover land or tenements? And what kinds of actions would be within that, and why isn't tri-title action one of them?
So, I think, of course, the Duras case is on point.
This is really about issue preclusion, isn't it? We're talking about claim preclusion here, at least the judge was.
Well, I think that the Duras case, the Duras court does say, you're right, it talks about issue preclusion, but it does say that Chapter 237, Section 7 doesn't bar using res judicata where title's actually been determined. And in the housing court, appellate court decision, I believe the court talked about the title of the property.
Well, let's not say res judicata, let's either say claim preclusion or issue preclusion. So Duras does not say that a housing court judgment, well, Duras really doesn't get into an analysis, does it, of what is an action to recover land or tenements?
It does not, you're correct.
Can you shed any light on that outside of Duras?
So, with respect to whether or not Mr. Bigelow's claim is a action to recover land, I would suggest that it's not, because he wasn't in possession of it. He was not the record title holder at the time when he filed the action.
But he was in possession of it at the time he filed, correct? He was evicted thereafter, but at the outset, the time of filing, and the judge said, you know, for jurisdictional purposes, I'm going to look at the time of filing. He was in possession, therefore that element isn't in dispute.
He was at the time of filing, correct?
Okay.
The land court case.
What kind of action would be an action to recover land or tenements, and why isn't this one of them?
Well, I think an action to recover land would be a situation where somebody has record title, or possibly where someone is filing an action stating that they have title to a particular piece of property, and there's a dispute between the parties with that. With this particular case, Mr. Bigelow does not have record title, and whether or not
But that would suggest that where you allege record title, if you're saying that an action to recover land turns on whether you claim record title, he certainly claimed that here. Whether he had or not is a different matter, but if an action to where you claim title is an action to recover land, then why wouldn't a tri-title action qualify?
Well, I do not think that a case to try title is an action to recover land, simply because what you're asking the court to do is to determine what the title is. There's a dispute there. It's not an action to recover land.
I realize this may be asking you to go back to the bar review course or even to first year property, but so we're looking for whether they're, which is difficult, but we're looking for
30
whether,
years ago.
I'm sorry?
Which was 30 years ago, right?
So we're looking for what the legislature meant when it said an action to recover land or tenements.
Isn't part of the problem that the land court didn't have jurisdiction to look into title until, or to look into defenses based on lack of the plaintiff's title until fairly recently, right? Isn't that last 10 years ago? The housing court, right? Yeah. I'm sorry, housing court. The housing, yeah. That's a fairly new innovation that the housing court, you can actually bring a claim with respect to the bank's title in a summary process action.
Right. I mean, I think that even even though Duras talks about issue preclusion, I think it's somewhat analogous in this particular case because Mr. Bigelow's argument is 239 section 7 completely bars under all circumstances using a housing court decision as res judicata. But I think putting that aside, I want to make this point clear, which is that with respect to Mr. Bigelow's title, his title was extinguished at the time of the foreclosure sale. So Mr. Bigelow, looking to jump back to essentially two owners based on this purported new evidence of forged deed and forged documents, he can't do that.
As far as Duras goes, you're not asserting issue preclusion, you are asserting claim preclusion.
We're asserting claim preclusion, that's correct.
So would that require us to extend Duras?
Well, obviously it would, because the Duras court focused on issue preclusion. That's correct.
But Duras recognized, I think, that in a prior case of this court, Santos, the court had applied claim preclusion or given a summary process judgment claim preclusive effect. Santos was not a tri-title action like this one.
Right. I believe that's correct. If there's nothing further, I would rest of my brief.
Okay, seeing no questions, thank you both. Actually, really interesting case, and gotta hand you, Mr. Bigelow, for a non-lawyer. You had a pretty good command of the law, so thank you both. So, we're gonna hear one more case right now.